Welcome to this episode of The Common Sense Skeptic with another edition of Musk on Trial. On February 21st, 2023, the Delaware Court of Chancery heard post-trial arguments from the parties in Tornetta v. Musk, file number 2018-0408, before Chancellor Kathleen St. Jude McCormick. This case is a class action filed by Tesla shareholders against Musk and the board of Tesla to relieve Musk of the ridiculous compensation package he has siphoned out of the company by way of share options to the tune of $56 billion. Musk and McCormick have crossed sabers before. She was the same chancellor overseeing the Musk v. Twitter acquisition trial that Musk abandoned when he changed his mind and reluctantly took control of the company he originally offered to buy out. McCormick's position to tolerate none of Musk's legal team nonsense very likely played a role in Musk's decision to follow through with that purchase rather than continue fighting against it in court. The main body of the trial in question for this episode has already been conducted, taking place in November of 2022. The parties were back in court to make their final arguments to the judge as a recap, and the proceedings were available to the general public by telephone, although no one is allowed to use recordings of that for any purpose, which seems odd, but those are the rules. We were not able to attend the conference call, but a good friend of the channel was. Chancery Daily on Twitter, or Chance the Lawyer as she's known on Mastodon, was posting her stream of thought as a lawyer while she listened in on that call. And, with her permission, we are going to take you through her thread, reading it aloud for those of you that like audiobooks, hopefully with all the humor and snarkiness she intended to deliver. Each of these frames will show the thread post number so you can find these posts yourself on her Mastodon account, and she will also be publishing this as a SUBSTACK. We've included both links in the video description. Keep in mind, these are not official transcripts, so consider everything in here to be a paraphrasing of what went on. Here we go, picking it up at post number 8, reading her post verbatim, just not in her own voice. Okay, we are doing introductions. The Chancellor sounds relaxed, which I'm glad to hear. She has sounded overwhelmed for the past few weeks. The presentations will be plaintiff, defendant, plaintiff, defendant. Plaintiff by Varallo jumps right in. He says it doesn't matter what we think of Elon Musk, it matters whether his compensation package to a part-time executive was entirely fair, which is the legal standard. Varallo is pressing first on the disclosure point. This is what I've been harping on in the various places I've been harping about this matter. Tesla decided to make the vote contingent upon a vote of the shareholders, and this requires full disclosure of all relevant information and potential conflicts of interest. Varallo says they win the case if a preponderance of the evidence shows either a material omission or misstatement in the proxy, or if we're able to show partial disclosure without an accurate, full, and fair characterization to place that partial disclosure in proper context. The evidence developed at trial shows both material omissions in the statements and materially misleading partial disclosures, any of which warrant cancellation of the plan for failure of a condition precedent. This previous point is interesting, and JSC Varallo is talking fast and really running through a lot, because he's saying not just that a new vote is warranted, but that the plan should be cancelled for failure of a condition precedent if the vote wasn't fully informed. This is a slight but also massive difference from what they were previously arguing. Now we are on to the specifics of the disclosures about the conflicts. Varallo is trucking right along. Again, here we are walking through the evidence that was marshaled at trial. This is what post-trial argument is for. What I find most interesting from all of this is how plaintiff has strongly shifted from an argument that this failure of proper proxy disclosure should require a new shareholder vote to that the remedy is cancellation. It will be interesting to look at the cases on this. You can think of this as basically a summary of all those tweet threads we went through at trial when this evidence was being elicited at trial from witnesses. Right now, Varallo is going through Ira Ehrenpress's conflicts. He finished going through Antonio Gracia's. This is generally a similar order in which they have consistently presented the evidence throughout, from strongest connections to weakest. Varallo pointing out that Ira Ehrenpress is the one who initiated contact with Musk in 2017 in the context of this case, arguing that his actions in this matter itself show his conflict in his relationship with Musk, in the way that he pressure tested the accounting advice that he got from Tesla's CFO to align them more with Musk's ask. Varallo for the plaintiff on Ira Ehrenpress's conflict as an independent director. When it came time to involve the committee itself, Ehrenpress seems never to have shared the genesis of the grant, allowing the committee to proceed without any detail about Musk's huge ask, where that ask's central role as the basis for the grant is not actually presented to the committee until 2 months after Musk made the ask to Ehrenpress. Now we are on to Robin Denholm's conflicts as a so-called independent director, who realized $250 million for 3 years of service. Varallo does a great job of showing how his friends really can't have it both ways. The court should either consider the actual realized value or consider the Black-Scholes model value, while the defendants want them to consider neither, since she hadn't sold before the approval of the grant and didn't sell until thereafter. Varallo is doing a very good job in my opinion here. He's very effective when he's on, and he's currently on. Indeed, the court may recall that Denholm engaged in an almost endless equivocation on the point, until the court broke in and required an answer. But I have to say I was somewhat amused to review testimony to find that the court had to ask the question 3 times yourself to get that answer. We're now running through the remaining committee members. Brad Buss, Mr. Murdoch. Think he'll mention Super Bowl with Dad and Sister? Nope, seems like he'll let it slide by oblique reference. Oop, no, there it is. Picture on the board and everything. Now I need to know if he used my screen cap of the Super Bowl or what. Varallo is now differentiating the case law and the arguments cited by defendants against plaintiffs' disclosure claims. The question is really, is there a disclosure claim that is viable in this information economy? Because if there is, this seems to be a pretty strong one. If the language of the case law still holds, despite this insane informational milieu in which we swim, this case seems to be on all fours on disclosure. Varallo has brought out the doozy. And I want to pause here because I gotta tell you, this one's a doozy, Your Honor. The idea that I could have invested hundreds of millions of dollars in private Musk entities, vacation literally around the world with him and his family and my family, owe him for literally handing me generational wealth, and that I, nonetheless, come into court and testify that none of that mattered to me because I was a really independent guy. Your Honor, if that's all a director needs to do to satisfy an independent director inquiry is simply to say that he wasn't swayed by evidence negating any claim of independence, then we don't have a system capable of enforcing fiduciary duties any longer. In Delaware, we don't credit self-serving testimony over hard facts. Now we are on to the disclosure about the grant's genesis and development and disclosure about milestones and their likelihood of achievement. There's a lot of baggage and backstory echoing in the background here about disclosure claims in Delaware that's hard to nuance in here, even with the 500 character limit. Be glad I didn't join a server with a 5,000 character limit. Varallo covering the probable of achievement disclosures. We have entered the S-curve phase, and Varallo has brought out the Immaculate Heart of Mary nuns and how they taught him to draw an S. And he's describing how Tesla explains an S-curve from a Tesla tweet. At the early part of production of Model 3 or any new car, it's not entirely clear that they're going to succeed. But there comes a point on the curve as it begins to leave flat and ascend where the production issues have been tied down, the production problems have been solved, and mass production is about to print money for the company. That's what an S-curve is. That's what this shows, and the testimony you got during the trial about where the parties were on the S-curve is highly probative of exactly how difficult it was going to be to meet these milestones. If we were on the upward slope of the S-curve, then these projections were highly likely to be achieved, and indeed, many of the milestones were highly likely to be achieved. If we were way at the left, then we have a different story. Laughing out loud on Musk being a part-time CEO. Varallo. Indeed, while Mr. Musk came to trial saying that he anticipated his full-time activity at Twitter to end, and I'm quoting, probably this week and next week, trial was November 14th to 18th of 2022, he was quoted in the financial press last week, on February 15th, as saying that he anticipated being able to appoint a new Twitter CEO by the end of 2023. After spending more than an hour on the disclosure claims, Varallo now turns to entire fairness, after reminding the court that she need not reach entire fairness if there is a finding that the grant fails for any of the disclosure claims. I'm not really clear how they are going to have time for rebuttal the way this is going. I submit to Your Honor that the board's wholesale lack of engagement here, including a stunning silence in the face of a less personal and very public jihad against the SEC, tells Your Honor all that you need to know about who dominates and controls this company and its board, and frankly the lack of character, integrity of the board, which is subservient to Mr. Musk. Tell us how you really feel. Talking about Musk bringing Boring Company and Tesla employees to Twitter, once again, where was the adult in the boardroom who stepped forward to say that Tesla was not Musk's playpen for which he could simply draw volunteers to his other pursuits? The evidence shows a founder CEO, single largest shareholders, self-appointed techno-king of Tesla, alone promulgates master plans for the company, running without board supervision and a board which is sufficiently empowered by him to sit idle while he single-handedly wages war with the company's primary regulator to engage the company's engineers for his private interest and contribute, sadly, to the deterioration of more than half of Tesla's market capitalization in a matter of a few months. Varallo is talking so fast, it's a good thing that the court has post-trial briefs with all this information. But they can't have more than 3 hours allotted for this argument, so he's got to have less than 14 minutes left of his time, so 10 minutes for rebuttal if he stops now, and he doesn't seem to be stopping. Or have I lost track of time and space again? Varallo: for those of you who drive new Teslas, this is pushing into ludicrous mode, he says of the compensation package. He's going through the entire fairness arguments in a ludicrous period of time, I'll give you that. I honestly think it wasn't a bad allocation of time, but I do believe he should sit down and save a few minutes for rebuttal, because the Chancellor is not going to go long, that's for sure. We're playing a Musk clip. Was this topic discussed with you? Musk: what do you mean by this topic? The topic of whether there should be some assurance about the amount of time you spend on Tesla vis-a-vis other interests. Musk: no, because that would be silly. Varallo says they didn't talk about it because they knew Musk would give them the back of the hand, and that the director's testimony equivocated about whether they had talked about it or not. Varallo with the burn: the court may recall such testimony in open court that Musk took the red eye to attend court. Apparently flying during the night on one's Gulfstream qualifies as the red eye. I didn't know that, but I learned it at trial. During the night. These are things only Varallo can pull off. Okay, so is he just going to get cut off? I'm so confused about the timing on this, but I guess it means that the Chancellor isn't going to get to ask any questions, so that's, I guess, not surprising, but an interesting take. She says they are at the break, and he says he will finish up on remedy. He cites a case for rescission of the grant. The Chancellor has no questions for plaintiff. She has one for the defense. Here it is, a question from Her Honor. The Chancellor calls a 15-minute break, but has a question for the defense to answer when they return. Plaintiff argues that one disclosure violation is a kill shot. She tells the defense that she didn't see a meaningful discussion of that argument in their briefs. I could have missed it, but I would like you to address that in your argument. Let's see how they respond. Back in 15, I have no idea how time is working here.
Let's all go to the lobby to get ourselves a treat.
Okay, we're back. Somewhat surprisingly, they are not going to address her question first, which seems like an interesting choice. Her response to their decision to not address her question right off the bat should tell you everything you need to know about their decision not to address her question right off the bat. She said, "I'll let you address it last, at the end of your presentation, but..." So now they have jumbled up the response order substantively, but also are not going to address her question directly firstly, which is such a bad choice in my humble opinion, I really do not understand. Taking a condescending approach to the Chancellor is a choice. Also, thank you for your answer that you don't actually have a response. It is so noted. In comes the Chancellor. There's a lot of nuance in her assessment of his argument about how she characterizes the way he's presenting the give and the get, re-process disclosures, but she's skeptical of how he's bringing it to her. She's not going to be steamrolled here, obviously, but it's not clear to be defendants are aware. She says again now, I have some ideas of my own, but explain again to me why you think process disclosures are less significant in this context. This is all very, very interesting. The Chancellor asked defendants whether, by analogy, process disclosures would be less important in a situation of a buyout where there is a controller-seller. There is a lot going on here. I'm going to have to unpack some of this after the fact to avoid getting bogged down here with backstory on process disclosures. The idea that Elon Musk is not a controller is so absurd, it's so condescending. The Chancellor asks what the reality is about his voting rights. She asks what the math says. He has less than a third and is not veto power. She wants to know what it means with respect to people not likely to vote, etc. The idea that they had to give him all the money in the world because they couldn't live without him, but that is also not his company and he doesn't control it. How do you square those two things? This is a lot of time to spend on the controller issue, to be honest, since there are a lot of ways they can lose this case before getting to this issue. Are the directors beholden to Mr. Musk because he made them rich? We believe the answer is no. Did he answer her question yet? As the Chancellor said, I might have missed it, but I didn't hear him answer her question. Did I miss it? Did I blink? The Chancellor, you've done a clever thing here. You have divided your presentation by sources of influence as opposed to the aggregate of those influences on each individual director. But, to be clear, defendants don't concede the independence of any of the directors from Mr. Musk, correct? Defendants say they will get to that shortly. It secures Mr. Musk's full focus in transforming Tesla. Oh, really? He goes to answer her question and she interrupts with a new one. Chancellor, plaintiff argues that potential conflicts can alter the total mix of information. Do you agree? If there's a real potential, yes, I would agree. But total mix means total mix that is important to the vote that is to be taken. She says he can continue to answer her question. Is identifying a material misstatement in the proxy a kill shot? He says he addresses this in the brief. He says there doesn't appear to be any precedent to what the court needs to do here, because it's in the discretion of the court because it's an equitable remedy. He cites to Solar City, which said the proxy was shitty, and still went to entire fairness, which is a hella take. Oh my god. I have so much to say about the last take. Mr. Musk would have an unjust enrichment quantum merit claim, which I would absolutely love to see it. She almost interrupts him but stops. So plaintiff argues that if there are material issues with the disclosure, it invalidates the award full stop. And there's an elegance to the simplicity of that analysis, which is why I'm skeptical of it. And you're saying that I need to move toward entire fairness. What's your best case for that? He asked if he can send her a letter, and again, cites Solar City. She says that there are no cases cited on the pages that defendants provided. He says it falls back to general principles of equity. He says entire fairness, therefore, applies from equity. Defendants argued at one point in that colloquy that Tesla predicated the grant on a stockholder vote within 12 months, and I swear to God he just said that they held a stockholder vote, so that condition was met. I promise that's what he said, as though the vote, basically irrespective even of the outcome or the conditions of the proxy or anything, would be irrelevant. I can't even. Holy shit. The Chancellor just straight up asked, who proposed the structure? To counsel, in court. Can I love this woman? Is that wrong? I mean, it's all so simple. It's so straightforward. It's just so basic. But it's like the State of Maine slogan. It's the way life should be. This lawyer is excellent, no doubt. But her confidence is still sometimes overstating the facts in a way that I don't think does her case justice in front of the Chancellor. Oh, yes. The Chancellor notes that it was partly Musk who pushed the negotiations partway through. Okay, she didn't exactly note that explicitly, but she obliquely points her question against the assertion that the board pushed the timeline out because they were so diligent in needing more time to do such good work. This lawyer likes to say that everything the plaintiff says is telling. It's really unfortunate that we don't get to see these demonstratives or trial exhibits. Let's sigh. It would be dangerous to drink every time she says something that plaintiff said was telling, unless you wanted to be very, very drunk. The point here is you have to treat Mr. Musk the way you have to treat Mr. Musk, because he's a special boy, and that's just how negotiations go with special boys in the modern age. And you don't do it by nickel and diming a billionaire, you do it by coddling their needs to a large extent. So like, is Evan Chesler just not presenting today? What is time even? Was this always going to be some weird, super long, oversized, bizarre length hearing the likes of which I've never seen? Okay, here he comes. He gets 4 seconds. He starts off with, left it to the old guy to run fast at the end. Chesler says the thing is about price, and he says that the key case, and the Chancellor interrupts and says, you'll have to tell me which key case. And to preview the end, she says she will want supplemental briefing, which means we are going to have some more months with this case after all. This was absolutely a foreseeable outcome here, but it's definitely not good news if you're a Mr. Elon Musk. Oh boy, Evan pounding the table about Elon Musk is, I don't think, going to impress anyone anymore. Our entire space program is being driven by SpaceX. Sir, this is a Wendy's. Mr. Chesler says that Mr. Chesler has houses nicer than poor Mr. Musk with his 500 square foot house in Boca Chica, and the Chancellor says that she has no doubt that is true. Even Chesler is a true believer, trademark, and he is big mad, trademark, at anyone who would question the Techno King's, trademark, absolute genius, trademark, in any way. Or, he is a very good actor. Your Honor, we are definitely really for real going to do opening, response, reply, and rebuttal. Okay, attorneys, and I'm going to have a unicorn and a flying pony and a 500 square foot shack in Boca Chica right next to Elon Musk's just as soon as you get good at time management. I didn't hear what the Chancellor just said about the share price. She was cutting out a little. Chancellor is going over some of the high points. I think he has 5 minutes left. I guess he was just always planning to go to 4:45 p.m. with a 15-minute break. Makes sense. Their reply and rebuttals were mere pipe dreams. Are you willing to give the give to get the get? That's what they were voting on. How could this be easy? They say the S-curve. Come on, everything is easy in the rearview mirror, not in the front view. Why were all the geniuses on Wall Street shorting this company? They were betting against them because they beat the odds. Ambition is not the same as expectation. Ahuja and the others didn't want to be paid that way because the metrics were too hard. What better evidence is there that it was hard? Restaino said that it was not exceedingly hard. That's the best they could get. Chancellor asked for 2 more points. She doesn't respond audibly, but presumably nods her acquiescence. Chancellor, I'd like supplemental briefing. Plaintiff's lead argument is the idea that one disclosure decision that meets the materiality standard is a kill shot. There are other issues that have come up today. I would like defendants' best cases on the give-get, not only in the disclosure context, but also on the fair price. The amicus briefs came in and they weren't directly addressed. You can address them in supplemental briefing. She will issue a letter if other things come up. And that ends the thread. All things being equal, given the questions the Chancellor asked and the clarifications she's looking for, the defendant's lawyer haven't earned their paycheck. Thanks for tuning into this episode of The Common Sense Skeptic. It's a bit of a cheat, but it quickly gets you up to speed on this massive court case against Musk in a timely fashion, and Chance did a great job covering today's proceedings. Since McCormick is now asking for supplemental briefs, it sounds like we've got months longer to wait before we find out how hard McCormick is going to come down on Musk. But if the Twitter pretrial was any indication of how this is going to go for him, Musk and his board would do well to be quite nervous. Special thanks again to Chance the lawyer on Mastodon or Chancery Daily when she's still on Twitter. We're very happy to have made her acquaintance over the course of the Musk 420 trial, and everyone is hoping for a very different outcome here. As for us, we have a huge episode coming up about the latest fundraising efforts of Orbital Assembly through Net Capital, for those that haven't seen our other 2 series focusing on these guys and the Gateway Foundation. Looking forward to getting your thoughts on that extended episode as well, hopefully within a week. For this episode, help the channel algorithm out by giving us a thumbs up, share it across your social media, make sure you're subscribed, and ring that notification bell so that you'll know when the Common Sense Skeptic returns.